Okay, good afternoon, everyone. This is the Senate Judiciary, House Judiciary Conference Committee. We're going to be walking through some House bills that we have in conference. Senate, I have tried to take the bills that have come through both chambers and tried to package them into some subject areas. Just going to walk through them maybe subject area by subject area and see kind of what areas of agreement and what areas of priority we have. The first one I have is I'm calling it a law enforcement bundle, and it would go into 2299. And so in that one, my preference would be that we put in 2299. And once I announce these, we can have the revisers review what they are and what the differences are. But 2299 dealt with the amount of time to do search warrants. Both chambers passed it out. The Senate changed the effective date, I assume, to get it in conference. And so we would propose going back to the original effective date. The next bill that I would want to put in is 2508, which is the bill that deals with the KBI's wrap-back program and fingerprint retention. In that one, the Senate added a crime to the underlying bill, which I'm fine with. So we would include that. The next one that I would add is House Bill 2582. This bill was actually introduced in both chambers. I don't know that it went through Judiciary, though. So there were two identical bills. What this does is it deals with information sharing between DCF and law enforcement. Priority of law enforcement, we passed it out. Senate passed it out, but it never crossed ways because we had two separate bills. And then the fourth one I'd want to put in this law enforcement bundle is Senate Bill 435. This one deals with expanding jurisdiction of law enforcement officers. It passed the Senate, it passed the House committee, but it was never considered by the full House. We have an amendment that if we were to include this into that package, I have an amendment. And Natalie, do you have copies of that? So let's go ahead and pass that out. So we would want this amended language. It tightens down a little bit, the expanded jurisdiction. I met with law enforcement to talk through how we could do that. And they looked at some language that's already out there in 2402, and we incorporated that into this. So my offer on a law enforcement bundle would be 2299, the original position with the original effective date, 2508 with the Senate's position, 2582, and then 435 as amended in this balloon that was just passed out. Does anyone need any explanations of what those four are? Representative Carmichael.
Thank you, Mr. Chairman. Could either you or the reviser explain to me what was added by the Senate to 2508, the KBI wrap-back bill?
Natalie?
Mr. Chairman, in the Senate Committee of the Whole, an amendment was added on the floor by Chairperson Warren, if I recall correctly, to add a crime. So it's the same provision that the House has, except an intentional disclosure of the information in violation of the section is a Class A non-person misdemeanor.
Sounds like an excellent idea, Mr. Chairman. Thank you.
Any other questions about those four bills? Senator Haley?
Thank you, Mr. Chair. And I was wondering if to the question of 435, if Revisor Thompson or whomever might help understand what the proposed amendment does. I'm trying to put it, so you see it passed 38-1. I was the one no vote concerning the expansion of Leo without some ratcheting down a little bit.
Well, I'm pretty sure this fixed your concern.
I think it does, but I was hoping that they would walk us through. If it doesn't, my concern's about to evaporate anyway. But I just want to see if he could walk us through, if one of them might walk us through with this, your proposed amendment to 435 would do, Mr. Chair.
Sure. Thank you, Mr. Chairman. So if you look at the balloon on page 6 there, right now, it talks about when a law enforcement officer is outside their jurisdiction if they see an illegal act. So this is changing it to activity that's observed because, that way they don't have to make a determination immediately whether that's illegal. You may not know whether it's illegal until after you've kind of stopped them. But then it kind of narrows the circumstances under which those law enforcement officers can act when they're outside their jurisdiction. So right now, as the bill reads, it would say if they reasonably believe something will jeopardize the safety of a person. And this would change that to they would have to suspect that a person has committed, or is about to commit a crime, and they would have to reasonably believe that a person is in imminent danger of death or bodily injury. So it kind of tightens that down to when a law enforcement officer would be able to take action in those circumstances.
Oh, thank you, ma'am, and thank you, Mr. Chair. How does this differ from our current law for what might be impaneling so-called citizens' arrests? I mean, the duty to intervene by any person outside of law enforcement if there appears to be crime about to be committed or that could result in death or bodily injury. Wouldn't many citizens be imbued with a certain ability to intercede? I don't want to expand this to any crimes in Georgia or following people who are running down the road, but if there is the belief that isn't there some protection for a layperson in our current law?
Mr. Chairman, Senator Haley, we would have to do a little bit more research on that because I'm not really sure, without kind of doing some more research, under what circumstances just a normal lay citizen would be able to act. So we could certainly look into that. But.
Okay, I appreciate that and appreciate your indulgence. And thank you, Mr. Chair.
Representative Carmichael.
Thank you, Mr. Chairman. If I might inquire of the reviser, I believe that this balloon amendment is actually patterned after an existing statute that relates to the authority of law enforcement officers to stop a person. Unfortunately, I don't have my materials on the balloon in front of me. Could you help refresh my recollection?
Mr. Chairman, Representative Carmichael, the language is kind of roughly patterned on KSA 22-2402. So you could find some similar language there about, when a officer reasonably suspects that that person is engaging in that type of behavior.
And that statute, does it generally apply to law enforcement officers who are on duty, et cetera, in their own jurisdiction, if you will, the corporate limits of the city or the county? As I say, I apologize. I did not bring my Senate bill folders this afternoon.
Sure, that's no problem. Thank you, Mr. Chairman, Representative Carmichael. So that statute is about kind of stopping a suspect, and so it kind of just presumes that the law enforcement officer is acting in their jurisdiction. So this would be circumstances where they can act when they're not in their jurisdiction anymore, but it's patterned off of that kind of similar circumstance.
Thank you, Ms. Scott. I appreciate your help.
Any other questions about this bundle at this point?
I do. Thank you, Mr. Chairman. I appreciate that Senate Bill 435 was brought to the Senate by the Kansas Association of Chiefs of Police, the Kansas Sheriff's Association, and the Kansas Peace Officers Association. And you had said that you had some discussion about the proposed balloon amendment with law enforcement. I'm thinking it was those associations.
It was. In fact, the language came from them.
Right. And so, and they approved and they are all right with that. And
yes.
Wonderful. Have a question about 2582. House Bill 2582 was not above the line in the Senate, Judiciary, in the Senate, and it was referred to Health, and I see the Health Committee made an amendment in the Senate. Could we have a discussion what the Senate amendment was? Because I think your proposal was to not adopt the Senate amendment in the bundle.
I'm not sure I know what that amendment is either, so.
Right, so let's discuss and see where we are.
Sure. Abe, can you find that? One of the buttons will lose lights, then the door, and. There we go. Thank you.
Okay. Mr. Chairman and Madam Chair, so House Bill 2582, we had to look as well because it didn't come through Judiciary, as you mentioned. It looks like the only amendment was the effective date, so.
I see that now too. Thank you.
Question, Mr. Vice President?
Yes, if I may. You mean the Health Committee made the effective date? That was the nature of the amendment? Thank you.
Okay, so if no more, we can certainly come back to these. So that's the law enforcement bundle. Let me move forward to.
Well, you're just proposing it. We'll need to discuss.
Absolutely. If it's okay, I think I may go through all the bundles so you know what bills I'm going to include and not include, and then we can kind of go through them and make a formal offer after we've had some discussion. So the next one would be a planes, trains, and automobiles bundle dealing with conveyances. It's really our two DUI bills, one dealing with aircraft and one with DUI. So it would go into 2377, and it would include 2377 and then 2387. I think we're fairly comfortable with, you made several amendments to 2377, which maybe if we could have the revisers talk through those, and I think Representative Ralph may have some questions there as well. So that would, on 2387, you simply changed the effective date, so we would propose moving that back. But 2377, you made several changes to. Yes, please.
All right, thank you, Mr. Chairman. So I get to be DUI guy again. So the first thing I just wanted to say on 2387 is the Senate did make some technical changes, right, to update all the dates and change some sentencing language that was consistent in all the right places. That was done with the proponents to make sure that it was correct, because we made a few errors along the way. So I think you'll want the Senate version of that, but to just double check. But I know you'll want the updated version, not the old version. All right, so then 2377 is the larger DUI bill. And as you mentioned, I'll just kind of focus on the changes, which on the chart that hopefully most of you have are underlined. That might draw your eye to them a little bit better. So the first one is on the persons who are disqualified from driving a commercial motor vehicle and having their privileges restored. The Senate added in SB 533, which was introduced late in the session at the request of the Division of Vehicles and the Department of Revenue. It increases the period of disqualification for a couple of offenses for folks with commercial driving privileges. You can see those on page 9 if you wanted to look at them. It also prohibits prosecuting attorneys from concealing certain traffic violations from their CDLIS driver report. And that's an ongoing federal compliance issue that I think a lot of you know about. But those are the two pieces from 533 that were added into the commercial motor vehicle provisions that were essentially already in the bill. I think we had to add one section to get all of them, but the others were already in the bill. And then on number 4 about the criminal penalties for driving a commercial motor vehicle under the influence or driving under the influence, the Senate added a number of not technical amendments, but sentencing cleanup amendments. We noticed some errors. We worked with the prosecutors and the other folks on the Judicial Council group to make sure that we got the sentencing language just right. One of those was fairly significant because it had implications for a large amount of federal highway monies. So that was one change that the Senate made that I think the proponents would advocate for money's sake, if nothing else. Then the next major change was, it's actually a pretty small change, but policy difference. Both versions have that compliance-based ignition interlock program, and satisfying that program through compliance before you have your device removed. The Senate changed from 3 standard violations being allowed in the final 90 days before you request reinstatement to 1 standard violation being allowed. So there's the difference. You both say no serious violations, but the House had 3 standard violations allowed. The Senate has 1 standard violation allowed. And those differences are on page 25 if you wanted to look at them. The next, again, small change but policy difference, was that the House had a sliding scale ranging from 25% to 90% of program costs that you would be eligible to, or that you would have to pay based on your percentage of federal poverty level for your income. And you allowed up to less than or equal to 300% of the federal poverty level to be eligible for the assistance for your ignition interlock device. The Senate reduced that number to 150%. So House was 300%, they're at 150%. So you would make, those making more than 150% of the federal poverty level would not be eligible under the Senate bill, but they would be under the House bill. So there's your difference. And in addition, once you qualified, you would be eligible for 50% of the program costs to be waived. Under the House proposal, you could have been eligible for much more than 50% to be waived, 75% or even 90% in some cases, depending on your level of poverty. So, and those changes are on page 28 and 29 if you want to see them in context. And then the last change relates to rules and regulations. In the Senate or in the House version, all the current rules and regulations and continuing ones would be handled by the Secretary of Revenue. The Senate added a provision from Senate Bill 146 that passed both chambers, or I'm sorry, it passed the Senate. Senate Bill 146 passed the Senate, which transfers rules and regs and the authority over the state certification of manufacturers of ignition interlock devices to the Highway Patrol. Our understanding is that's already done through a memorandum of understanding, but this makes it official in the statute and transfers some, money and other things with it. So they added the provisions of 146 to this bill, which means that under the Senate version, the Highway Patrol would have oversight of the manufacturers and the service providers and the devices, essentially, but the Secretary of Revenue would maintain control over the compliance and the amount of money you would pay for the device, that determining your poverty level and determining how much you pay. So it's a bifurcated system as opposed to all of it being with revenue under the current, or under the House proposal. That's the main things. So the SB 533, the 2 differences on the ignition interlock device program that I mentioned about the number of violations and the pay, and then the final thing is SB 146 and the transfer of rules and regs and oversight.
Any questions? Representative Ralph.
Thank you, Mr. Chair. Madam Chair, I might just make a couple of comments in regard to this particular piece of legislation, since it is pretty extensive and very broad and very good legislation. I would like to say this is the culmination of 2 years of work in the Judicial Council by a group of individuals made up not only of prosecutors in the state, defense attorneys in the state, the Judiciary, the Kansas Department of Revenue, our law enforcement agencies, as well as the Attorney General's office. And during those 2 years, brought quite a variety of pieces of this legislation forward, finding consensus over those 2 years of meetings. I just wanted to at least take a moment to give consideration to those folks and the time and effort that they put in to do that. The one item that we will get to in this, many of the amendments that were put on by the Senate look appropriate. I don't think we're going to have a problem with them. The one that we'll ask for a concession on has to do with the 3 standard violations versus the 1 standard violation. And I know we'll get to a discussion of those, but at this point, I'd like to at least give some basis for why that is going to be requested. During the course of all of those meetings for the Judicial Council, since we specifically in regard to prosecutors and defense attorneys all working in the same place, we worked very hard to find those areas where consensus could be found. Areas where there could not be consensus because of the responsibilities and duties of both of those particular groups. If there was a spot where we could not find consensus, we did not bring that forward or bring recommendations on it. So each of these items represents some type of a compromise between those particular groups to get to these particular positions. And so that's why at this particular point in time, if there was a spot that we couldn't reach consensus on, it wouldn't have been here. And as you might expect, this particular item is one that the two groups reached consensus on to get to that particular spot from their different representative constituencies. So when we get to that place in terms of the conversation and looking for compromise on that, just wanted to give a little background as to why that would be the case on that item. Thank you, Mr. Chair.
Senator?
Yes, thank you, Mr. Chair. One more comment to add to Representative Ralph's comments. The language in here as it relates to much of this is very fragile as it relates to compliance with federal funding. So tinkering with that too much can get us in real trouble. So I just want to make that comment.
Representative Carmichael.
Thank you, Mr. Chair. My recollection is that the Vice Chair of House Judiciary served as a co-chair of the Judicial Council and spent 2 years laboring over this legislation, and I trust that we will recognize his efforts as well. Thank you.
Any other questions on this DUI bundle? Okay, next, let's look at a possible crime bundle. So this would go into House Bill 2508. Here I'm one heavy. I'm trying to keep 2387 empty if we want to use it. Well, let me just go ahead and say that. So 2385, if we can keep it empty, it could take 2495, which is a charity bill that was brought to us regarding the disclosure of information for 501c3. So I'll get back to that. But 2508 would be the crime bundle. In it, I would propose 2508. Oh, no. Hold on, Natalie. It's still in 2508, though. So I put 2508 in the law enforcement bundle, but we'd have then an empty shell. Okay, so it would still go into 2508, but we'd no longer put 2508 in it. Instead, the options would be 2277, which is definition of possession. We passed it out. I believe you all heard it, but I don't know that it made it any further out of your committee. So 2277. 2447, that deals with the two-way electronic audio-visual communication in preliminary hearings. 2674, that requires forfeiture of an appearance bond to be set aside in certain circumstances. 2697, which is a bill that came to us from KDADS that has to do with mobile competency evaluations. 2362, that deals with the elements of abuse of a child. Actually, that is just 5 now that we took 2508. So that's just 5. That's 5 crime bills. So again, 23, now it's a different order because it's the order that are listed on mine. So 2362, Senate worked, but Senate did not work yet. Heard but not worked. 2447, that's the two-way communication and prelims. 2674, appearance bonds. 2697, KDAD's mobile competency, and 2277, which is the definition of possession. Yes, Natalie.
So, Mr. Chairman, because you are now moving the contents of 2508 out of this, you could use 2299 as the shell for this bundle since 2299, and then make 2508 your law enforcement bundle. But either way, it won't be difficult to draft that either way.
Okay, perfect. However you best see fit to assign the bill numbers. Any questions about these? Yes. Chairwoman.
Thank you, Mr. Chairman. So I don't think that any of the 5 in this particular bundle made it out of a Senate committee. And in fact, most of these were just referred to a Senate committee in the last week. So most of these.
You're several at least.
Pause.
So I guess my first response would be we passed out of committee all but one of your Senate bills. So there aren't any Senate bills for me to negotiate back with. So we are left with House bills to try to put in a crime bundle. The two that came out late, the KDAD's mobile competency evaluation, that's one that on our side was introduced really late, like days before. Actually, I think it was introduced on the deadline to introduce bills. We heard it as quickly as we could. There were some neutral testimony that was raised, and so I told the parties to get together and come up with an agreement. It was clear that not only KDADs wanted this, law enforcement wanted it, prosecutors wanted it, but we really had no true opposition. It was just some concerns with the language, and so they spent several weeks trying to come up with an agreement, and we finally got an agreement, and that's why it got to you late. So I didn't want a product to come out of committee that had problems, and so I encouraged them to work together until we could come up with something. I do apologize that it came out late. I think you've received a letter from the Sheriff's Association outlining the importance of why they believe it should be moving forward. And if that's one that you know, while we break and discuss this, you want to visit with those parties, I'd certainly encourage you to do so. It was conveyed to me that it's really important due to costs and people waiting in jails and those types of things that we want to try to get addressed. So that's that one. The two-way electronic audio-visual communication, that did come to you late as well. We had a much more comprehensive bill. It was 2537 that dealt with preliminary hearings. It would have allowed hearsay. It would have given more time to do the prelims, and then it also included this provision. After we heard that, it was clear to me that my committee was not going to support all of that. And so it wasn't moving anywhere until I heard from prosecutors, and they asked if we could give them this one piece because they thought that would be important and help with their job duties in that area. So that's why we included that one. And another reason it was late. Let's see, 2674. That's one that actually came out of our corrections committee. It passed out, it got below the line, but before it was worked, it was sent to Judiciary to take another look at. House leadership had a few issues with it, and so we heard it again. We amended it. Actually, the chair of corrections had an amendment, and so we fixed it. That's another reason for its lateness. The abuse of a child, that's been out for year plus. What was my other one? Let's see. Oh, the definition of possession, that came out, I think, early last year as well. So, yes.
And I'm not
no, I'm just
judging on the lateness.
Right.
I'm just saying none of these five got out of a Senate committee. So that's where we are.
Right. Got it.
And,
completely got it. So
okay.
I understand that.
Thank you.
So that's the crime. Any questions about any of those for Natalie or Jason or me?
And I think of the five, only one had a full hearing, 2362, and 2277 had started being heard, but then we suspended it and didn't finish the hearing. So
okay.
Just kind of logistically where they are on the Senate side in the process.
Got it. Okay. So then, again, we can come back to these. So then 2387, I would use for, assuming, which it sounds like we're not going to have more than five we agree on. So if we have an empty shell, 2495, that's the bill that deals with the prohibiting disclosure of personal information that 501c3s have, or 501cs have. That we would use that bill for a shell. Any questions on what that bill does? I'm not tracking. 2387, we would put in the contents of 2495. 2387 would not be part of. So 2387 would be empty. We would only put in 2495. We're putting it into 2387. We need a dry erase board. It's an empty shell, and it would have the contents of 2495. So let's see, that's 4. So 5 would be, we would use what we would make an empty shell of 2109, and my hope is 2109 had to do with the makeup of the bids board. We passed that out of the House last year. I think you guys, I don't know what the status is on the Senate. Yeah, and I non-concurred in it, so you passed it out. My hope is there's a bids bill that has to do with with compensation that is between Ways and Means on your side and one of our budget committees. And so I've talked to the chairman of that committee, and I'm hoping he can put 2109 with that and create a bids bundle somewhere else, which frees up 2109 for us, that we would put in a bill that the House has not heard, but it's one we have to do. It's Senate Bill 507. That's our annual exceptions to the Open Records Act bill that for some reason, which is one of the easiest bills we should deal with each session, it always ends up we're trying to find a home for that in conference. So next year, whoever's in these chairs, we should get that one done early. But so that's what we would use 2109 for, is Senate Bill 507. And those are the 1, 2, 3, 4, 5. Yes, those are the 5. So you kind of loosely know what an offer would be, but if we can continue to have a dialogue, maybe we can get closer before we have to exchange true positions.
I understand. I think on this side, we understand what the proposal for the outlines for the 5 bundles would be.
Okay. So do we want to break for a little bit for each side?
That would probably be a good idea.
Okay. So do we want to set a time or just recess for a bit? It's 2:30 right now.
I would suggest recessing until 3 o'clock.
Sure, me. So yeah, let's recess till 3 o'clock. We'll be back. Thanks, everybody. back, everyone. So before we hand it off to the Senate, I just want to make clear that everything I walk through would be our global offer. The one thing that it didn't come from my mouth, so I want to make sure it's part of our offer is Representative Ralph indicated on 2377 that our position would be 2 standard violations instead of the 1 that was in your bill. We had 3 in ours, and so just want to make that clear. So as we work through this, we'll see where we end up, but that would be our offer.
Thank you, Mr. Chair. So the offer is then kind of the middle ground between 3 and 1 on 2377. It would be 2 on that.
Correct, Madam Chair. And I might point out to the Vice Chair's point, several of your amendments are technical, and we don't want to mess with those because of federal considerations. This one does not affect that. This was strictly within the committee. Thank you.
Thank you. Regarding, well, we don't have the written bundles, but what you conceptually described as the first bundle, would there be any room to consider adding Senate Bill 395 to the bundle that includes 2299? 2299 is a search warrant issue. Senate Bill 395 is can't enter property without a warrant. So maybe there's some room, I don't know, whether to add in Senate Bill 395.
Could we get a reminder of what 395 is?
Oh, I'm sorry.
No. Oh, okay. Okay, I got it.
So something to consider. I don't know if the revisers would, if that's appropriate to add in.
My initial thought, would it fit? Yes. I mean, it pertains to law enforcement. That's a bill. So I don't remember what the vote count was on your side, but it passed out your side. It 30 to 9. It came to our side. We had a hearing. We began to work it in committee. It got tabled. In the midst of some discussion, there was some confusion. There was some misunderstanding. It got tabled. We tried to take it off the table a couple days later, and that did not happen. So that's, if the House has a position, it's that. We can certainly visit about whether or not that should be part of it as well, though. So yeah, we're open to have that discussion.
Let's keep that discussion going. Would appreciate that. Thank you. And regarding the second bundle, which would be House Bill 2377, we just heard Representative Ralph's proposal on that one piece, change it from 1 to 2. We just heard that. And the third bundle is the 5 bills that none of them got out of a Senate committee. 3.5 of them didn't have a hearing. And we do have, for now, while we keep the discussion going, one proposal on one of the House bills, and we'll have Vice President.
Thank you, Madam Chair. We would propose stripping the fentanyl strip amendment out of 2277 without going into a lot of reasons. The fentanyl strips.
If my memory's right, when it left committee, that was not on there, but it was added on the floor on our side. Okay.
And then for the fourth bundle, which is an empty shell of 2387. The proposal from the House is to insert 2495, and the response conceptually from the Senate would be to add 2495 to the fifth bundle that the House has proposed in 2109, which would be 507 and 2495. They're both records type bills. And then that leaves 2387 as a shell. Oh, and actually, let's switch before I finish this. Let's put looking at the fourth and fifth bundles that the House talked about. The proposal conceptually from the Senate is to put hold on just a second. Let me make sure my notes are correct. Just a moment. Thank you, Mr. Chair. So the proposal for the fourth and fifth proposed bundles from the House would be to put the contents of Senate Bill 507 and House Bill 2495 into 2109, into the shell of 2109. If that's clear.
Leaving the shell of 2387 at this point in time.
And also Senate Bill 507.
Yeah, 507 is not a shell.
Okay, it's conferenceable because it passed out of the Senate.
Right. Okay. I think that makes sense. So let us chat for just a second on conceptually where your counter's at. Oh, what time is it?
We do have caucus at 3:30, and if it would be possible to have you all discuss that while we're at caucus would be a suggestion, and if we could switch to Senate Bill 286 for a minute. We do. We have our third conferee here. Come on up. Thank you, Mr. Chair.
I'm good with that. Sure.
Thank you, Mr. Chair.
I think we can maybe do both before you have. What time do you have to leave? 10 minutes? 7 minutes?
Yes.
So on 286, just an update. We're still in the same position we were this morning.
So let me clarify if we could, since I've called that committee. Thank you. And with that, then, there was a House position, I think, still on the table. There was a Senate position still on the table, and the Senate withdraws its offer and rejects the House offer as well. So we're kind of back to where we started, I think, after conversation. But with regard to Senate Bill 286, then, the proposal from the House, from the Senate, is this. I'm scrolling through to get to the right part here. The part of the bill is that both parties agree on both sides, the House and the Senate, that we've agreed since this came to conference committee, is regarding Section 6. And regarding Section 6 of the bill, which is on page 9, starting at line 27. So the Senate offer is Section 6 of the bill.
So just to clarify, Madam Chair, just the extension of what we're calling business immunity. Is that correct?
Yes, that's correct. Okay. Section 6 is current law that the House and Senate have previously agreed upon, and there were no changes made in the House to Section 6 from what is current law, other than changing the date to make the provisions of this section expire on January 20th of 2023 rather than on March 31st, 2022. Okay. So let's start with what we all agree on, and then keep open for discussion the other provisions of SB 286 as it came over to the Senate from the House. So the position of the Senate is to keep discussion going on those other issues, of course, and with the offer being Section 6 of the bill.
Very good. We will consider that while we are away. if you could give us just a second, we might be able to get you some feedback on the House bundles if you want us to, or would you prefer we just wait on everything? I'm open either way.
We'd have to switch out conferees again. Hold on just a second.
Well, it's going to take us a second. So give us a second.
Let's just stand at ease.
Okay, so let's stand at ease for just a few minutes.
Thank you.
Please. CS?
Now, wait a minute, are we going to the House bill?
Oh.
Well, if we're back on the House bundle,
back on the
we
House
need to
bill.
excuse Senator
Yeah.
Corson
Can
and
we
invite
swap out again?
Senator Haley.
So we're back on the House bills, just to give you some feedback on.
Right.
On
Welcome
what,
back, Senator Haley.
So here's where we're at. On bundle one, you'd proposed adding the contents of 395. And again, this is a global bundle, and assuming you're agreeing with the rest of our positions, which I'm not 100% sure if you are, but that's if that's the case, then we are acceptable to adding the contents of 395. On bundle number 3, you wanted to remove the fentanyl strips from 2277, and while we think that's important, we also think it's important to move some of that forward, and so we're okay with accepting that position. And we are also okay leaving bundle number 4, which is 2387, empty as a shell at this point in time, and combining 507 and 2495 together in bundle number 5. So, yes, Representative Carmichael.
Thank you, Mr. Chairman. I am disappointed to hear that the Senate does not want to facilitate the legal availability of fentanyl strips. People die because of adulterated substances that contain fentanyl. It kills kids. I'm not going to hold up this global bundle with an agree to disagree, but I think the Senate is making a grave error in placing that demand in their package. Thank you, Mr. Chair.
So with that said, we think we're headed in the right direction and are acceptable to the changes that you would like to see in our bundles.
Appreciate that, and let us confer for just a moment.
Okay.
Thank you. I'll let, there was one issue about House Bill 2377 that the Vice President would like to address.
Thank you, Madam Chair. And in respect to Representative Ralph's offer, we accept that. That makes a good compromise. And matter of fact, we had thought about doing the same thing. So, and it doesn't affect the financing, doesn't nothing. Thank you.
Very good.
So with that, conceptually, we look like we have agreement on the bundles, and I think there was one last question, though, on the first bundle, 2299 and 2582. There was an amendment that, am I not remembering that correctly, or did we address that about whether we were also adopting the amendment or we weren't?
Natalie.
Mr. Chairman, I would just note, so even though the Senate didn't take action on the contents of that bill in that House bill number, they did take action on Senate Bill 425. And you know, their version passed without the amendment that you guys added in House committee. So I think that's what Senator Warren was referring to about the differences between your two versions. That passed out of Health, not Senate Judiciary.
Okay, so just to kind of explain that amendment, that bill came to us from our Children's and Seniors Committee. It got below the line. Leadership was a little concerned about the sharing of information, wanted to make sure that information never became a public record. And so it was referred to Judiciary after turnaround for us to take a second look at. We looked at that, and with Natalie's help, we determined we weren't really concerned about this information ever becoming an open record. But we did come up with 5-6 words. I mean, it's not very much that we added just to clarify what those records could be used for. We visited with law enforcement about that, who was supportive of this, and they were in support of that language as well. And so that's why we added that little tweak. I don't think it really changes the bill much, but it made leadership on our side a little bit more accepting of the bill, and that's why we did that.
And where's the little tweak?
Yeah, Natalie. I don't have it in front of me. Well, maybe I do.
So if you look on the House version of the bill, 2582, it would be on page 6, starting at line 12. And so that was, you would have seen that over there when you guys handled this bill in your committee. And then the portion about what law enforcement officers can use that for, let me find that.
So that looks like the same section. This was in Senate Health. It wasn't in Senate Judiciary. So that looks like the same section that Senate Health amended as well on page 6. That's subsection E there.
Oh, so the House Committee on Children and Seniors added that first part, the name and the contact information of the reporter or the persons alleging abuse or neglect, and case managers, investigators, or the contracting agency. That was the amendment that House Children and Seniors made. And then when it came to House Judiciary, they added, such records shall only be used for the purposes of investigating the alleged or substantiated report or investigation of abuse or neglect.
So the Senate Health amendment at page 6, lines 10 through 13, is that part of what is in the House version as well? And if not, is there any objection to also adding it?
Okay, so yeah, the House version now includes the amendment that both House Children and Seniors made and Senate Health made. Those matched. The only additional amendment that was made by House Judiciary was that last sentence about what law enforcement can use those records for.
Thank you for clarifying that. It looks like they both melded before they got to us here today. So right. Great. So, okay. Conceptually, it looks like we have what we need, but let me check just a moment.
Okay.
All right, just checking one last time with law enforcement on a couple of amendments, and they're satisfied. So
awesome. Okay, so if we're in agreement, we can go ahead and have revisers prepare conference committee report.
And ask them to prepare the reports.
Okay, please do that. And then you guys need to get out of here. So why don't we?
That would be on 286.
286.
Then, if we're adjourning this.
Yeah, so I guess we're finished on the House bills for now. So we will adjourn the conference committee on the House bills, and you can call another one on Senate Bill 286. We're on the floor at 5. Who knows what's happened in this building in the last 3 hours? So maybe we have work to do. Maybe we don't. We'll find out at 5. So we're all available all evening.
If necessary.
Let's get this done.
On 286, right?
On 280.
So you're finished, Senator.
Stand at ease just a moment. Want to thank the House for their work with the Senate on the House bills that we had in Senate and House Judiciary. So thank you, Mr. Chairman. And we're on the floor at 4, so I'm not sure how long our work will take. So rather than call and cancel something, we will go ahead and send out a notice on Senate Bill 286 when there's time and availability and work together to continue to take a look at that.
Awesome. Thank you.
Thank you.
We are adjourned. Thanks, everybody.